This is Greenwood's Legal's Employment Law Nowcast, episode 14. This is the one about immigration changes. Enjoy the podcast.
Well, hello and welcome everybody to the latest instalment of the Greenwood Solicitors Employment Law Now podcast. This is the one about changes in immigration, and we're very pleased and very fortunate to be joined today by Sherry Fitzgerald from SAR London, who are immigration specialists, and we're going to be talking about the changes that have come about recently and are in the pipeline in relation to, in particular, we're going to be looking at right to work checks and changes to the skilled worker route to bringing people into the UK. So welcome, Sherry.
Thank you, Keith.
So, as I say, there's been some changes. It seems it's like a bit of political football, the world of immigration law. Every government wants to put their own stamp on it, and this current government no different. But what should we talk about first? The changes to right to work, I think, are pretty fundamental, and they're going to affect a lot of people.
Yes, that's right, Keith. So you're absolutely right. I mean, every government wants to make their own mark, and immigration is always one of the first areas they look to tackle. This isn't the first time a new government has made announcements of significant changes, but these seem to be sort of the most tightest we've seen in terms of targeting economic migration. With right to work checks, so the previous government did make some changes last year. The fine for recruiting illegal workers increased to £60,000 per employee.
Yeah, that was a really big jump, wasn't it?
It's a really big jump, and it's always been important to make sure that your business has the correct right to work checks in place, but more so than ever, because the fines are huge amounts of money, and it's important to note it's £60,000 per illegal worker. Now, the way companies can mitigate this is simply by carrying out the correct process. If they've done the correct right to work check, they followed the process correctly, then they have a statutory excuse. So therefore, even if the individual in question is found to be an illegal worker, they can demonstrate they carried out the correct check, they will not be fined, and they're safe.
Right. I assume that the trick there is making sure you've carried out the right check, and is it being able to demonstrate that you've carried out the checks as well?
That's right. So now the checks for British, Irish and settled person, it's still a document check, and you will need to retain a copy of that document. But for any sort of migrants, anyone on a temporary visa, the check is through a share code on the Home Office website. So there will always be an electronic record of that you've carried out the correct check. Where companies could stumble is if, for example, they're not aware that they now have to do it through a share code and they still continue to do a paper check on their documentation. They could find that that's now not the correct process, therefore they're liable. It's really important to make sure that your business has a robust right to work policy in place, that anyone recruiting or in HR or responsible for bringing in new workers is aware of that. And the critical thing to remember is right to work checks have to be carried out on all staff, regardless of their nationality. So British, Irish citizens, anyone with permanent residence, you do still have to carry out a right to work check before they start employment with you.
That's interesting, because I've been encountering that for a number of years, where my clients have been saying, well, we didn't need to check that person because they're obviously British, where they meant they looked British or whatever, which was always bad practice anyway from a discrimination point of law. But in terms of immigration, it's required.
It's a really common issue. A lot of people are under the misconception that if someone's British, there is the whole thing of they're obviously British, but also they may just flash a British passport. They still have to do a right to work check. The only difference is with those people, you just do one right to work check at the start of their employment. Whereas anyone on a temporary visa, you need to have a system in place to continue doing those checks at the visa expiry point to ensure that their right to work is continued. Because at the time they join you, if they're on a temporary visa, their right to work isn't permanent. It's until the point of expiry of that visa. So it's really important to distinguish between the two, but that for businesses to be aware that right to work checks must be carried out on all employees, regardless of their nationality, whether it's implied or obvious, or they show you a passport. Make sure you do the correct check. The current government are going further now with the right to work checks, because they have announced haven't confirmed when, but they have announced that they are looking to bring in right to work checks for your non-employees. So if you have somebody as a contractor, self-employed, 0 hours contract, in the future you are going to have to do right to work checks
So
on
for
those people.
all workers, all contractors,
Anyone
everyone
working for your business, doing any form of work. Like I said, they haven't announced a time frame when this will be introduced. From an immigration perspective, it is now in the right to work guidance that it's recommended you carry out checks for anyone that's self-employed if you're a sponsor. So any contractors, it's now currently recommended, but at some point in the future, it is going to become mandatory.
Right. You mentioned the guidance there. In my experience, the guidance on some of these things, some of it's hopeless and not very useful at all. Some of it is useful but technical, and some of it's user friendly. Where would you put the guidance on that sliding scale?
The right to work check actually is quite user friendly. It sets out the policy quite clearly. It's not too technical. Because actually, if you look at the right to work check process, it is quite a simple process. It's just an administrative burden, particularly if you're a larger organisation. But the process itself is relatively straightforward if it's done correctly.
Okay, so as a starting point, if anyone watching the podcast isn't sure they're doing the right thing, they can Google the official guidance, and that may be of some help, which you can't say of every
Exactly.
government
And
guidance.
we offer right to work training. We offer guidance to employers. We often have our clients that are slightly unsure about whether they've done something correctly. As immigration advisors, we can't do the right to work check for employers, but we can definitely provide guidance and training on how to do that.
Walk them through how to
Absolutely.
do it.
Absolutely.
Yeah, because as you say, if you get that wrong as an employer, the financial penalties now are really, really substantial, aren't they? As you were saying.
Exactly. The financial penalties are huge, but also if you're a sponsor, it could also have implications on your sponsor license. It could lead to a revocation of your sponsor license, which means if you have a large sponsored workforce, you're unable to continue sponsoring them, which means your workforce you'll be short staffed. It will affect your business. So the knock-on implications could be significant depending on your business. But as a starting point, there would be a massive financial consequences, and they can also face imprisonment.
Right, imprisonment. Right, and that's
obviously
probably
extreme cases.
It is an extreme case, but it's enough. It's enough for people to know that this is stuff that you've really got to take serious as a business.
It's a very serious issue, and it's getting more so. And now as well, it's affecting. Like I said, it's got bigger it's affecting more and more. So, for example, now if you are a business and you're looking to sponsor migrant workers, you're in that position now where you have no choice but to go and get a sponsor license. If you, as part of that application, if the Home Office discover that you haven't done the right to work checks correctly beforehand, that could have an impact on the decision. What we're seeing more and more is the Home Office, as part of their compliance visits, are making decisions against companies where they haven't been compliant in their right to work check previously. What we're noticing as well is if, as an employer, you bring it to their attention and you rectify your mistake, that's fine. But if at the time of application the Home Office find out you haven't carried out correct right to work checks, it could lead to a refusal of your application.
Right. Yeah. So I suppose the answer there then is if you're going for a sponsor license, or if you're renewing it, perhaps it might be prudent to get someone in to do an audit to make sure that you're compliant.
Yeah, I mean, sponsor licenses you don't renew anymore. So they I think it was a year or two ago. They're now valid indefinitely.
Right.
That's a new thing. But yeah, absolutely, you're absolutely right. If you're looking to get a sponsor license, it is important to have an audit. That's a service we do for our clients. So we would do a mock audit where we would review the files and we would look at all the right to work checks. If there are any, like I said, now because it's done via the Home Office share code, it's important to get them done on the day before they start their employment. But if you have missed one, it's always better to put your hands up, do the correct right to work check, and again, we can offer full guidance on that.
Right. No, that's so. Yeah, compliance is key, as
Mm.
with so many things where you're coming into contact with government bodies now, that there's this expectation that you will be compliant, and if you're not, you will get hammered
Yeah.
pretty hard.
Yeah. I mean, compliance has always been, we've always said to our clients, compliance is crucial, but now more so than ever, because now it's being scrutinised a lot more at the application stage of your sponsor licence, whereas previously the duty to be compliant in line with sponsorship duties was always once you got a sponsor licence. It could now affect the outcome of your sponsor licence application.
Right.
It's also worth noting that if you have a refusal of a sponsor licence application, in most instances there is a 6-month cooling off period before you can
Right.
reapply for a sponsor licence. So if you're in a position where you're applying for a sponsor licence because you have a critical staffing need and you are refused due to non-compliance, that's only going to further damage your business, because you're not going to be allowed to reapply for another 6 months. So it's sort of food for thought.
Yeah, and I've got to say, in my experience, there's some people that approach us to raise these issues about immigration that we don't deal with in-house. Occasionally it's long-term planning, but much more often than that, it's a very immediate need. We've got someone, we've identified someone, they're absolutely perfect for the business. We need to get them into the country as soon as possible. So yeah, it's almost never at a relaxed timescale, is it?
And this is something I say to clients quite regularly. It's important to plan. I know obviously things in business sometimes can be unexpected, but you'd be surprised the number of people come to us where they've got somebody on a graduate visa or a visa that's about to expire, and they're fantastic, and the business can't do without them, and they need them, and they haven't got a sponsor license. And we say, well, when does their visa expire? Oh, in 4 weeks' time. So it is important to plan as far ahead, particularly with changes coming up. And we'll talk, I'm sure, in a moment about the changes to skilled worker route, but also in terms of things like the scrutinising of compliance and the right to work checks. It's important to allow yourself sufficient time to get everything in place to recruit that critical person to your business.
Absolutely. Yeah. As you've raised it, should we talk about the changes to skilled worker route? So I've seen it's been a big headline in the news, hasn't it? For that things are going to be changing. Just fill us in, Sherry, on the sorts of things we're expecting to see.
So the biggest and most significant change is the recent announcement that they're looking to increase the skills level threshold from level 3 to level 6. So just to give you some background, in order to sponsor a migrant worker, the job has to be at a particular skill level. Up until Brexit, it was always level 6. So a level 6 job would be a degree level job with some managerial, some responsibility. Following on from Brexit, they did reduce it to level 3, which was more sort of school level, college sort of A-level role. It was a massive benefit for industries such as leisure and hospitality. Care workers were brought back into the skilled worker threshold. But for leisure and hospitality, it was huge, because it meant roles such as bar managers, floor managers, restaurant managers, chef. Well, chefs have always been on the shortage occupation list, but it meant those roles could now qualify. Because these sectors were hit hard, not only from Brexit, but also COVID. A lot of their workforce went home and found it difficult to re-enter. And had they not lowered the threshold, it would have been impossible. So what the government are now looking to do is bring it back to level 6. And there are, in addition to leisure and hospitality, there's other more junior roles that could be affected. Things like accounts technicians, more junior IT roles, more junior sales roles. They could easily, warehouse operative is another one, which is sort of fruit pickers and so on. They were previously on the skill levels. There is a seasonal work, but it's temporary. We have clients that want them permanently. So these sort of roles are at risk. Unhelpfully, we don't have a time frame as to when this will be done, but it's looking to be sort of end of summer. It could be as early as end of summer.
Right, so it's and some this year.
So that's the most significant, and it's going to impact a lot of businesses. Another area we have a lot of people where they've been on a graduate visa, which is the visa issued to people who've studied in the UK for 2 years. They're now sort of in more junior roles with career progression at UK companies, it may be that those jobs don't qualify.
And is there one of the headlines I've seen is about an increase in the salary requirement?
So there is talk of the increasing of the salary requirement in the region. There haven't been a definite figure hasn't been published, but talk is it's around 52,000 for a minimum salary.
Is it mid-30s at the moment?
At the moment,
somewhere there?
At the moment, there's two sort of salary rates. There's the new entrant rate, which would be for people that are on a graduate visa or under the age of 26, or in the UK on a student visa. The minimum for them is 30,960. Right. But anyone else the minimum salary is 38,700. Yep. And in some instances even higher, because what the rules say is that's the minimum threshold or the minimum on the SOC code. Right. So any role you sponsor has to be mapped to a SOC code. A SOC code is the list of occupation codes issued by the Home Office. Right. And each code has a minimum salary. So in some instances you could be paying higher than 38,700, but that is a base minimum you're looking at.
Yeah. It's always difficult, isn't it? Because the government will be facing, really strong pressure to bring down immigration, and they've got to try and find a way to be doing that. But yeah, it's whatever they try and whatever they do, it is going to have real impact on real businesses, isn't it? And that's kind of a fact of life.
Yeah, and that's what's interesting. I think it's the biggest shake-up of the economic migration route, because usually when new governments want to shake up immigration, they do focus on sort of the asylum, the family routes, and tightening those. So it's interesting that the changes that have been proposed to the economic migration route. But like I said, well, let's wait and watch this space.
Yeah. Let's see what happens. But no, that's been really helpful, Sherry. It's all change. It's we've been doing podcasts about the changes in employment law as well. And I suppose if you're going to have a change of government after 14 or so years, then if nothing's being changed, then you wonder why there's a change of government at all. So change, I think, is inevitable in this stuff, isn't it? But it's about being, if you're in business and trying to run the business best you can, it's having a heads up of what's coming down the track and being able to prepare for it as well. So what we'd do with this is we'll make sure that SAR London's details are in the notes around this, so that if anyone wants to either contact you and your team direct or through Greenwoods, they know how to do that, because as you say, it's all you can do with this stuff is be ahead and be prepared, isn't it? It is going to happen, we expect it's going to happen.
And we're happy to speak to anyone. Have a no obligation call. Sometimes just a fact finding call. And some businesses are probably more organised than they're aware. They know and they're fine. But there are a lot of companies where because they're running their business, they're not experts on the immigration rules that we can add value to. And we're always happy to help. Whether it's the one-off training or support. I mean, we can also manage company sponsor licenses for them.
Okay, yeah.
So it can be, the possibilities are endless. It's such a big thing that the level of support will vary from company to company.
Yeah, no, absolutely. No, that's really helpful. So thank you again, Sherry, for coming and helping us out with this topic, because it is one that people need to know about. So that's it for us for today. Thanks for watching the podcast, and we'll see you again next time. Thank you.